Very good morning, participant friends. Today, for this morning session, we have the young faculty from computer science and information technology, my friend Pravin Yannawar. He is the actually behind this FDP start from beginning, and even though this whatever with the support I am taking for this online organization of this FDP is totally from him. Okay, it's a great privilege for this morning to introduce him for this first session. He did his master from computer science and information technology, where he's right now a faculty as an associate professor in 2001. He qualified set of Pune University 2006 and did PhD in the same university at Dr. Babasaheb Ambedkar Marathwada University in 2011. His research profile is having the various means like diverse publications in different areas of research in computer sciences. Having the publication is 85. 4 patents are he applied for that. It's IH index is 13, I10 is 18. Citations are around 1,000. He is recognized as a AD scientific ranking from for last year, and in continuation of this for this year also 2020 and 21. Based on the last 5-year Google profile of research. He's completed uh, 4 projects from DST and other organizations, government of energy, sorry, India, and he's working on one mega project that is a multidisciplinary project and community project that is for SCST, having the funding from Department of Science and Technology that is more than 2 crore, and is also working on a CSR fund uh, uh, on some biomedical application based industrial project. With this, I request Pravin to take a charge of this session. Pravin, please.
Yes, thank you, Dr. Bhaskar, for this nice introduction. And at the outset, I must thank AICTE Atal for giving this opportunity, Dr. Bhaskar for giving this opportunity to interact the people that those are actively working in the areas of nanoscience and material science. So I must thank you all before starting this particular session. Due to some academic commitments, we have I requested Bhaskar sir to reschedule this talk, and he has accepted the request, and he has given a trouble to you all because we are starting this particular session 1 hour prior to your defined schedule. So please accept my apology for that, and your inconvenience is deeply regretted in this case. Okay, so let me share the screen, and the topic which is being given to me for the purpose of discussion is uh, about intellectual property rights, and we are going to discuss this intellectual property right in the context of researchers' perspective. So I want this particular session to be highly interactive, and your participation is very much expected in this particular course of discussion of 2 hours on this intellectual property right. Though this most of the people are aware with the conceptual view of this intellectual property rights. What I did is I have organized this particular session in the context of two things, like what is actually the intellectual property right, uh, what we called as an invention, and how that invention is being protected, how an invention is being protected, what can be protected, what cannot be protected, right? Because we would like, just take a case, the time we go to a shopping mall, we decide that what is to be procured and what is to be avoided, right? Though there are some fancy things associated with the products, but still we avoid the product. Okay, so means what is to be procured, what not to be procured. uh, the same decision we are going to have, what is to be patented, what is not to be patented, right? So we will try to understand this particular point of view, because being a researcher, we want to protect our idea, at the same time we want our idea to get patented also. Okay, so we, being a researcher, we must understand, or we must know about, like, whether my idea is being patented, or it can be registered or not, right? Or if it is being registered, it can be commercialized or not. Or if it is going to be commercialized, how do I get a monopoly right? Means, how do I get a intellectual property right? So that is what is actually the research perspective, researcher's perspective. So what is to be patented, what is not to be patented. After that, after discussion of that particular segment, we will go with, I'll just try to give you some hands-on detail about the things, about the things of how we can go for incorporate um, uh, patentability, like how we can ensure that the work is going to be, or it has a promising opportunities for getting it registered. How we can decide this, and this decision can be based on some kind of search. So I will tell you about some international databases from where you can incorporate your search prior to the registration of your uh, uh, idea. This is what actually we are going to do, and that will take around good time for, and intently I am going to spend much of the time onto that particular segment. If you are aware with that, then that is okay. But if you're not aware with that particular concept, like how we can go and source the content, so that particular segment you will understand here. And after that, I will close up this particular session by giving you, by sharing you some of the IP statistics, which are actually important in case of a researcher's perspective. This is all about today's 2 hours organization, like what we are going to discuss into this particular 2 hours. So at any point of time, if you have some kind of questions as such, I request you to please raise your hands so that I can take your questions. And I'm frequently going to check the chat box also, so so that I can answer to your questions if there are any. So let us go with the discussion on this particular concept of intellectual property rights and the researcher perspective. Okay, so let's go ahead now. Yes, this is about the uh, opening up of discussion here. Normally, this we have seen everywhere, right? Like whenever we work with the whenever we work with in a research areas, right? So the our problem is like elephant. Okay, so and this story, I think you have all aware with this particular story. This story is about elephant and seven blinds, right? So this is elephant and seven blind. So this elephant is representation of the problem. So this E stands for elephant, and elephant is nothing but your problem. And these blinds B are nothing but here are researchers. So so this is a fantastic relationship between the blinds and the the points and the problem. Okay, so if you look at the researcher look at this particular uh, organs of elephant in a very different way. So that is this particular different, like say now this we'll just name it. Say for example, this is A, then this is going to be B, this is C, this D, E, and F. So everyone is looking this particular elephant in a different context, and this is nothing but the perception. Perception, and this perception talks about the idea and approach. Right? This perception talks about the idea and approach. So this particular perception also deals with the kind of problem that you have taken, right? So this is also dealing with the problem. Now, as we understand that, like, okay, so elephant is a big problem. Elephant is a big problem. So from that particular problem domain, we have selected a specific problem. So this is going to be a very specific problem. And to handle this particular specific problem, we have an idea, we have an approach. Now, this approach turns to be a method. This method leads to some kind of instrumentation and some kind of processes. This involves some kind of processes. And overall, this idea is going to complemented by this particular method. Okay, so so this is actually the area of the interest of today's discussion, that if I have an idea, how do I convert this particular idea into an intellectual property? Okay, or if I have an idea which is supported by an instrumentation or a process, then can I see the opportunity in registering my idea, instrumentation, and process as an intellectual property? Okay, now, but whenever we are trying to have whenever we are thinking into this particular segment, we usually what we do, we have an idea, we have a process, and we have actually method. Instead of this process, we have a method. So what we have idea, we have process, we have method. Then we start on experimenting, and we come across with some result, and we start immediately, we wait for a publication. Okay, and I know that you all have very good publications with you, right? But see, having a publication is owning a copyright. This is very important. Having a publication is owning a copyright, right? And this copyright, like once you have a copyright, then you can yeah, you own this particular thing, but people can come out with product generation through your kind of publication. So you need to think about holding an intellectual property and the copyright for this particular publications. But the case is that whenever we are trying to hold this copyright in that particular segment, nowadays we need to pay the article processing charges, right? And this for holding this particular copyright, for holding this copyright, we need to go for APC, right? That is article processing charges, right? To the journal particularly. So but instead of investing the money to holding a copyright, we say that we grant it to the journal, right? So we transfer our copyrights to the journal and trying to have an access, free publication of your article. So we usually do this, right? All do this, but those who have funding with them for holding their copyright, they may hold this. But but in initial case, what I have seen, initial stages, what I have seen, that this particular your copyright and your work means, like, see, just try to understand this concept, right? That you have an idea, you have method, you have instrumentation, you have a process, but copyright holds by your article's copyright is being holded by the journal. Okay, so this is really what is very critical, that you invested your time and the copyright of that article is being held by a journal or the publication agency whosoever is publishing your article. So in that case, if someone come up with particularly a technology based on your idea and your instrumentation, your method, then still you cannot claim for it, right? Because you don't have a actual property right to restrict that particular individuals, right, for doing so. So in this particular case, we have to have an intellectual property right with this. So holding a copyright as well as having an intellectual property, these two things are very important in case of a researcher perspective. Right, this is important. Okay. Now, one thing I would like to tell you here, right, since this concept has come like idea process and method, idea process plus method is result, and we go for a publication, uh, uh, then I think you should seriously question yourself, like what is actually your idea about publication, right? What is basically the intent about a publication? Intent about publication or having a publication. Having a publication is, I hope, this is my personal opinion, is to convey idea, right? So my intent about publication is to convey idea, right? But what I have seen is that people are conveying idea with POC, proof of concept, right? This proof of concept with particularly results. Okay, we usually every time it is said that okay, if we have results, then our idea is being considered to be a very valid idea, right? Okay, but if you take your intent of your publication is conveying idea and inviting people to collaborate in this idea, collaborate in the work, is very important, right? Normally, please try to understand, see if we take it as a problem and research, this is the problem. So it's not a case that only A is working, B is working, C is working, right? There are n number of fellows simultaneously working on the same kind of problem. So but you never know like who is working on what kind of thing, right? So if you have really come across with a very interesting problem, you write on paper and convey the idea and ask people to collaborate onto this particular segment, and this is going for an innovative research. If you are going with this is going to be an innovative research. This is very important. So innovation in research lies in this particular way, that the intent of publication, you need to understand why you are writing an publication is for conveying idea. If you convey an idea, then certainly which is talking about this approach we are not following. So before going with this, right, I want you people to be the first person who is speaking about an idea onto a particular problem. So convey idea, invite people to collaborate in the same idea, right? So you will be the first person who has proposed an idea and open up an area for the discussion of the for the people. So open up an idea, invite people to collaborate, then in that particular case, you are leading to an innovative research in all the way. That what I have seen, that there are two approaches. One is like extending the what we have seen onto Google, extending that particular work with a different approach, that is what is called an extension of the work, right? But it is not an innovative work. Now in case of holding an intellectual property right, you need to think about whether I am really going for an innovative research or not. Okay, so this is really very, very important. Having an innovative research is very important, right? So now we will talk about this particular segment into the session. right? So before going into that, let me try to share some more important and interesting facts with you all. Right now, in case of intellectual property rights, we have just discussed about how we have reached to the innovative research, right? So if you look at this particular scenario worldwide, so there are interesting facts. Okay, so what are those facts? Like, we need to understand like uh, mm, um, like how many patents that are being registered worldwide, right? So if you look at the cases, if you look at the cases, like there are around 32 lakhs 76,700 patents actually filed worldwide in 2020. This data I have taken from a WIPO database. This is a recent data. So in 2020, around 32 lakhs applications were filed. So which is near about 3.3 million people have registered their ideas, right? So their application growth, if you wish to see. So if you look at this particular application growth, you'll see that there are this patent that is nothing but your IPRs are being registered here. Then second segment of intellectual property right is like about holding the models, right? So this is again going to be an IPR. Right? Then you're going to have a trademarks. Then you are going to have an industrial design of the particular process. So if you look at this, so maximum submissions are with respect to trademarks. Trademarks by which you can understand that this is particularly owned by a particular company. Say you have a trademark which is like written C like TM, so that nobody can copy the same kind of name and the trademark or the kind of a signature by which the product is being identified. So that kind of intellectual property still is being holded by many of the people, because now world is a global market, right? So we need to understand this. So if you look at this particular world scenario, as far as your intellectual property is concerned, right, you need to understand this particular segment as well, that in case of 2020 there are 3.3 million people those have filed their application. There are around 3 million utility models, around 17.2 million trademarks, and around 1.4 million people that have come up with the industrial designs. Okay, so this is this is the world scenario which is. So you need to see see the people are very particular about their work, right? So this is important. And as a matter of fact, I will share one important point here, that the sources for us will be like, see, researcher is very happy if he or she gets some kind of reference material from the Google around about his particular topic. So for the sources for a particular researcher is actually Google, right? Is one source for getting a appropriate reference, right? This is going to be like a search, right? Incorporated a search, and by this particular search you come across with some. Okay, but if I ask you do you know where the maximum work is being registered? See, around, if 3.3 million ideas are being registered per year, if average, if you look at this, this is beyond the publications. This is slightly less than the publications that we used to produce every year, and this world is producing every year. So if you compare this particular area with the two segments, if the publications are, say, around, say, 10 million publications are being just a part of discussion, right? This is around 10 million of publications you are going to uh, uh, see every year. So out of this, like, there are 3.3 million, around 3 million public people are filing the patents, right? So innovation and the technology transformation lies into this particular segment, right? Right, and very few commercialization can be expected, is being expected from this particular case. So for us, Google is searching for this particular data. I'll come on to this particular segment as well. I'll let you know. But like Google is giving references onto this, and we are trying to. Most of the researchers are trying to extend their particular work in the context of this particular documents that are being provided to you. So which is which is nothing but an extension of the work. So the commercial actually good and good reference work is being available into this particular 3.3 million documents which are being published, right? So actually your innovation lies here in this particular cases. So the interesting fact is, like, if you really wanted to extend or engage yourself into research, you must before prior starting to your work, you must see instead of this publication databases, like you can go for Thomson Reuters, Scopus, Web of Science, right? Instead of this, means along with this Thomson Reuters, Scopus, right? Web of Science, Google Scholar, or Google. Instead of referring this particular, or along with this, I think you should go with the searching the content into this patent also. So the scope of this particular session is this also, that how you can go ahead into this, right? So this is about the world scenario, about the total number of application and their growth of application, which you can see expect uh, into the world scenario. Now if you look at, like, okay, now if we understand that there are 3.3 million patents that are filing every year, then which region actually uh, go for this, right? So if you look at this, so if there are 3.3 million 3.3 million patents are filed, then out of this particular segment is Asia, right? So Asia countries this particular cases, and this is rest of the world. Okay, so the interesting part is, like, okay, if this is the case in 2020, then out of 3.3 million, say 1.5 million or 1.6 million, less than that is towards Asia. Then what about India into this particular context? That we need to search about. Okay, so if this is the case, like if this is the case, then certainly it comes that which patent office has received many applications. So if you look at this, you will find that the China patent office is receiving around 45.7% of the application of total submitted application around the world. So the China is leading ahead, right? China is leading ahead. So in case of India, in case of our India, in case of India, we have 4 patent offices, 4 IPR offices actually. So there's this, like, one is Delhi, Kolkata, Chennai, Mumbai. So this is handling North India, all submissions from North India. This is East, this is South, and this is Western region, right? And this is the headquarter actually. Okay, so as far as India is this, so we have 4 offices. So but if you look at this world patent application, the China is holding the 45% of the share. Okay, so let us look at the India side, right? Okay, so here our country stands. Here our country stands. Okay, it would be different graph if you look at the total number of publications, right? So we are at very good position as far as number of publications are concerned, but at this case, if you look at if you wanted to look at where actually we stand in case of technology and its commercialization and holding an intellectual property, so we stand in this particular way. As a country, we stand in this particular way. Okay, so you look at here, like in case of 2020, our IPR submission has been increased around 6%, right? Around 6% we have increased. Okay, so this is about the standing. So China stands first, US, Japan, Korea. This is European Union, EPO, Germany, India, Russian Federation, Canada, Australia, and likewise. Okay, so this data I have again taken from WIPO. Okay, so now what are the interesting areas? Like if this is so, then you must be thinking of in which area the intellectual properties are being registered, right? Okay, so you just take a case like in case of digital communications, or in case of digital communication, computer technology and audiovisual technology, China is holding the positions, say first, second, and third. So in case of China, if you look at in case of China, then most of the IPR stands with the areas of digital communication, computer technology, and audiovisual. Right now, in case of all your energy materials and that, your if you look at Japan, Japan is the Japan is the country which is holding maximum number of uh, IPRs in the areas of electrical machinery, apparatus, energies, and all that. Right. So Japan is standing first in this particular segment, as well as computer technology, as well as measurement scales. If you look at US stands first at computer technology, second at medicinal technology, and third at the digital communication. So medicinal technology, which is like the composition of the drugs as well as the medical instrumentation as such. So you can think in this particular way. If you look at Republic of Korea, then you will find that okay, digital communication, computer technology, energy, right, where they are again standing. And if you look at Germany, they are standing with energy, they're standing with transport, actually, energy and measurement. So it is like this. So this is the area where you need to think about. Okay, and I'll endorse here Professor Manoj Gawande, who has given this particular session, and he has revealed some fact that okay, if you look at the Samsung, you just go through the presentation where he has shared that Samsung Electronics holds the maximum copyrights into the areas. Okay, so these are the top 10 applicants, here. Those are filing the patents internationally, maximum patent internationally. So it is like look at Huawei, Samsung, Mitsubishi, LG, Qualcomm, and Oppo, like Sony, Panasonic, and likewise companies are filing their patents here. Now here, the term which comes in front of us is called as PCT, that is Patent Cooperation Treaty. PCT stands for, this can be asked into your examination. So PCT stands for Patent Cooperation Treaty. Patent Cooperation Treaty. Okay, so this PCT. India is accepting, India Patent Office is accepting PCT applications. So this is as per IP law, intellectual property law, 1970. Okay, so in light of this, we are going with the PCT applications. Okay, so patent cooperation treaty. This particular segment, I'll just explore it here only. So like, see, I have one IPR which is I have submitted into India, and I want to register this same IPR into multiple countries, right? The same technology into multiple countries. Then with this PCT, you can apply it to the rest of the world. You can submit the application into the rest of the world. so which is giving you a right of a global, if it is granted, it is giving you a right of global territory right. So or else your intellectual patent, a particular patent is giving you a territorial right, right? Territorial right means, say for example, you have got a patent IPR for India, so you cannot use the same IPR into Australia or USA or China or likewise. So in order to have an territorial right of a word, you need to go for a PCT application, right? And you can do this particular PCT application within 18 months, right? So so you can go for it. So you can actually think of doing it, right? Okay, so how to do that? That is a different process. So I'm not getting involving you in doing that. But for this particular point of time, we'll try to understand that this is the way the things are being done. So PCT stands for Patent Cooperation Treaty. This is as per IP law of 1970. So so you can easily go ahead with this. Okay. So so these are some interesting facts at the world scenario. Okay, now there are some interesting facts about the databases also. So we know that there are two ways to have access to a database. One is about the free databases that are available, and about the paid databases that are also available. If you look at this, you have a free database of Google patent indexes. So where Google has indexed more than 87 million patents with the full text. By full text, I mean, let me share this. By full text, I mean complete disclosure of patent oblique and IPR, including specification, including abstract, including drawings, including claims. Okay, so this whole repository is available to you, and you just see how many, like if 3.3 million is just an year, so Google patent free database is giving you almost 87 million patents with full text from the patent offices, right? And that is exclusive from 17 countries, but like there are 100 plus countries are available, 100 plus countries are available into PCT. So you just imagine the volume that you can expect here, right? So, and these are the technology where, like, these are the documents on which the technology is being developed, right? So Google patent indexes, this is one more segment. Then you have a USPTO. Then you have USPTO stands for United States Patents Trademarks Office. So you can have an access to this particular data. You can also have an access to the European Patent Office, China's Patent Office, Japan's Patent Office, Korean Patent Office, a World Intellectual Property Organization that is called as WIPO. All this particular data which I have shared is from WIPO only. Then you have a Dutchess Patent and Trademark Office also. So they are actually available. And at the same time, Indian patent data is also available as a free of cost. So you can search all the materials that are related to the particular IPR from these offices, and I'll tell you like how you can do that, right? So this is about free databases that are available. About paid databases, the list is being provided to you here, right? So you can, there is no point in like reading the same list, but the list is provided. So these are the pen database, right? Okay, so now if you look at the registration of IPRs, usually This is really very simple process. This process is really very simple process, and I have learned whatever I am sharing here is based on my personal experience, right? So I'm sharing this you in the context of researcher's perspective. So it is really very simple process. There are two ways, right? Any person, any natural person, we can say any natural person, any entity, any natural person is a individual, and entity means a company, right, or an organization. So any natural person can submit the application. So this is with respect to India, IPR with respect to the Indian side, India offices. So any natural person or an entity can submit the IPR by their own. So the process is made so simple, right? So this is actually the case. So you have to go for, actually you need to incorporate search. You need to, based on the search, you need to decide the patentability of your invention. You need to decide the patentability of your invention. Then you need to go for two options. You can go with registering it as a provisional application, or you can go with the complete application. Okay, so there are two ways, like provisional you can immediately submit it, and complete you can submit, like from provisional to complete you can go with plus 12 months. So within 12 months you need to convert your provisional application to a complete application, right? And by then once you have a complete application, say you submitted a provisional, then plus 12 months you submitted a complete, then you need to go for a publication, right? Then you need to go for examination. And based on examination, there is grant. Okay, so this publication, your patent gets published in 18 months time. You can go for early publication also, right? So you can go for early publication also. Then this examination has to be done within the 48 months, right, from the filing of an application. So once you find a provisional, from that within 48 months you need to go for a request of examination. You need to submit the request, and the process goes, right? And this is being done by either by your individual person, or you can go with the patent attorney itself. So there are two ways to do this. So one is you can individually do, or you can go with the attorneys. So, right. So if you go with the individual, there are very less number of charges, right? And if you go with the attorney, the charges varies from 35k to 55k. So these are the what the charges. Even student may go for in a concessional rate if the attorney approves, right? So these are the rates which I have seen today itself onto Google. You can search for these rates. You can also find out. But like for individually, you can go with the very less charges, and the charges are nothing but the required fees of patent office, required fees of a patent office. That is the only charge which you need. Okay, but you need to go with this particular ways. Okay, so these are what some interesting fact about the databases. You can go with this. Okay, now there is two important thing, like since we have gone for a concept of innovative research, we have exposed with the innovative research, then we need to see about the clear discrimination about discovery and invention. Okay, now and I know that you all are uh, uh, having good and precise information onto this particular context, discovery, what is a discovery and what is innovation. So now Christopher Columbus has discovered America, that is discovery, which means that discovery is nothing but you are recognizing something that is already exist exist in the universe, and for the first time that nobody has found it before, right? So you are discovering. So mostly, if you look at the plant taxonomist, right? So they are discovering the species. Okay, so that species already exist onto the earth, but that was not discovered, right, till that particular report is being done by a taxonomist. So in that case, that is a discovery. Okay, now if you look at invention is like Thomas Alva Edison has invented electric bulb, right? So means what, creating something totally new with one's own idea and the development. Although, like, if you look at invention, it is completely new to the uh, world, but the physical material needed for this production is already known, right, or exist. So if you look at electric bulb, uh, right, so the glass was also there, filament was also in place, but the mechanism of putting it at the right place and in the right way is nothing but an invention. So there is a clear distinction between the discovery and invention. So we are thinking about this invention where the things are there, but we are putting it in such a way that it is giving us a totally new product which is not already exist. Okay, so this is what actually the invention lies. Okay, so we are interested into this particular segment, and all we are mostly, since you are a material scientist, so I'm a computer researcher, computer technology researcher. So our work specifically lies into this particular segment, right? Invention kind of segment, right? So the things are in place, but we wanted to develop it into an entirely new format. So if we understood the clear distinction between what is actually discovered and what is invention, then we need to think about actually what exactly the patent stands. Okay, so what exactly and patent means. So as I said, the patent is a monopoly right. Patent is a monopoly right uh, given to the innovator for the exclusive use of the invention for the limited period of time. Okay, so that is called as a term of a grant, and usually term of a grant is for 20 years from the registration to the commercialization and its use. So if you look at this particular scale, this time limit is very less, right? If you look at this 20-year scale, right, this is 20-year scale, right? 20-year scale, this is really very small scale, because this is where is your idea, right? Your first 48 months, first 48 months means what, your first 4 years actually goes in between registration to the approval, and then you have got this 16 years in your hand, right? 16 years in your hand. So this is just 16 years time. Okay, and in this particular 16 years you need to renew your license upon grant, so that you can hold your IPR. It's not like if it is granted, then you are leaving it, right? It's not a case. If it is granted, you need to renew it every year, right? So you need to renew your license every year upon the grant of. So this for 16 years. Anytime if you lose on renewing, you are losing the claim onto a patent, right? Simple. So since it is a monopoly right, and which is given to the inventor for the exclusive use of an invention for the limited number of time. So you need to see the commercial aspect. So I would like to share here that since this 20-year is very less time, from the first day itself, you need to think about the commercialization of the technology part, right? So once you starting with the idea to registration, so that you can take a maximum benefit of this particular duration. What happens after 20 years? It is public, right? So it is publicly available, right? So this is really very important. So so this is important. The protection of period is for 20 years. And what does patent protection means? That the invention cannot be commercially exploited or commercially used or exploited without a patent owner's consent, right? Patent owner's consent means without your consent. If you have a granted process, without your consent nobody can exploit or use it commercially. If it is found, you can take a legal action against that particular unauthorized access and commercialization of the technology, right, which is based on your particular work. So you can sue them into a court, right? So that is particular right you are going to have. And it is a territorial right. Now when I say it is a territorial right, so it means that if it is granted for, if your work is granted for India, you are allowed to work in within this particular domain only, in this particular Indian context only. But if you want it to file on to the rest of the world, right, ROW, rest of the world, then you need to go with PCT. PCT stands for Patent Cooperation Treaty. So this you need to do. So means your application should be converted into a PCT application, right? So means you have a normal application. So first is a normal application, right? This normal application will help you to define your priority date. Define your priority date. Now by priority date means what? The date by which your patent is being registered. So that is your priority date. So say if there is a dispute, say there is a person who is A and there is other person is B, right? And they come up with a kind of technology, say C kind of technology, so or a T kind of technology, then the authority has to decide who has registered it first, A or B. Say if it is registered with A first, means A has got a priority date earlier to the priority date of B, so A holds that particular right of the technology, right? As a matter of fact, this is important. So priority dates are very important in this particular case. So when you go with a normal application, you own the priority date, you claim for the priority date, and from natural application you go with a PCT application. Say you can go with DCID, right? USPTO, right? Then European Patent Office, then JPO, then Canada Patent Office, right? Like you need to decide the areas where you wanted to register your particular application. So this PCT application is valid all over world, right? So this is important. So now what is granted? If patent is a monopoly right, then what is granted? So patent is granted for an innovation which is particularly a new product or a process involving inventive steps. Okay, involving inventive steps. So this is really very important. This is really very important. And all we are doing this, we have inventive steps and capable of converting that inventive step into a product or an industrial application. So we'll see that what exactly inventive step means. So inventive step means, like if you take an example, this is a ladder actually. Look at this particular. This particular ladder. This particular design of this ladder, once a step ladder is registered in 1862, right? I have served this. So this is Ohio patents and innovation from Ohio inventors. So this is actually registered in 7th January 1862. Just look at the time, right? 1862. So 18th century. This particular design at that particular instance of time, if this got designed, this got registered, means what? The fellow who has got registered this particular step ladder, holds a monopoly right. So look at what we were doing at 1862 and what the people are doing at 1862, right? So like this is what actually holding this particular right for this ladder. So this has come up with a design. Now if you look at now this to this now, right? So you have got an inventive step, right? Okay, so you have got a different design, right? So see, this has this, like this is right. If you look at this, you can have uh, a flat base here, the flat base here, but it has two ways, right? One way for getting up, other way is getting down, right? It's like this. So this is how the things are being done. So if you look at here, you'll find that the designs are being modified, right? Modified this particular design. So it has an industrial and commercial application. So this can be a chair also, right? So this can be a chair also, a step chair, right? So where, because this has given a rest to the back of the person, right? A person can sit here, right? Now here person can sit, but you cannot have a backrest here. Okay, it's like that. Now take a second example here, right? You have got a pencil, right? Pencil, you have got an eraser. These two things are different, right? And but when you combine these two things together, which is not explored prior, so it was not obvious to have eraser with the pencil, but we find it obvious right now, right? But the time it was designed, it was not at all obvious. So it got, that particular design uh, uh, got intellectual property, because at the time that has got design in that particular time, so that has got a significant important. Okay, so inventive step means it is an feature of an invention that involves technical advances as compared to the existing knowledge, right? Or having an economic significance, or both, that makes the invention not obvious, right? Not obvious means non-obvious to the person who is skilled into the art, right? The person who is skilled into the art can define whether it is uh, really whether it is an inventive step or not, right? So it is inventive step always talks about the technical advances as compared to the existing knowledge. Now, what is person skill in the art? Person skill in the art means a person who knows in and out about the concept, is called person skill in the art. So it involves the technical advances as compared to the existing knowledge, or having economic significance, right? Okay, uh, like it is not technically so advanced, but it has an economical significance, like say the cost of the technology or the product which you have designed offers at the lesser price, by which what happens, by which the expenditure incurred onto a common person's pocket will be less by using that particular technology. So it has an economic significance. So in that case, the step is again a inventive step. Okay, so economic significance makes a sense, right? Or both, that makes the invention not obvious, right? Person not obvious means it's not obvious for a person who is in the skill of the art. So it is, when it is non-obvious, it is an inventive step, right? So inventive step would be mixing of the two into a product. Say for example, one is pencil, another is rubber, eraser. So we are mixing these two products together, or we are formulating this, or we are combining these two products in such a way that we have a pencil followed by rubber. Their arrangement is at the end of the pencil. So this is how it is. Okay, so this is totally non-obvious. Okay, so this is an inventive steps we can think of. So I'm trying to make the term simple to you. So this is an inventive step. Okay, so if you look at this has an inventive step, and we are we have understood that what exactly innovation means, what is a patent means, and for what patent is granted. Patent is granted for inventive steps, right? So if you look at invention, then it is all inventions are covered under a section 2(1) of J. So this particular section of this particular section is IP law. This is the section under IP law. IP stands for intellectual property rights. This is under section of IP law. So this is covered under section 21J. So invention step means, again, invention means it is a new product or a process. Okay, now what does a new means? New means what? Invention must not be, right? What terms we say need? It must not be published in India or elsewhere. That is new. Prior to the publication of this, prior to the submission of the document, right? It should not be published in India or elsewhere. So in a prior public knowledge or a public use within the India, or claim before any specification in India, it means new. Okay, what happens now? What I have seen is that that many people, like, see, you have, as I said, you have idea, you have method, and you have a product, right? Design on this. So you have idea, method, and product. You have three things. You go for publication, right? And then you think of holding IPR, right? Okay. So idea, method, product, you go for publication, and upon publication you hold for IPR. So if you go for publication, it goes into the person who are in the skill, having those skill, acquired number of skill, to in order to understand. So for some of the people it may be obvious, for some of the people it may be non-obvious. Okay, some people it is obvious, for some people it is non-obvious, right? Based on, if it is a non-obvious, it is an inventive step. Okay, so if you have come across with a publication and stating a non-obvious step, right, you can prove that this is going to be a non-obvious step for the person who is skilled in the art, then you can get it done within 12 months, right? Within 1 year of publication of document, not beyond that, right? Not beyond that. So I would request you every number of time, if you come across the inventive step, right, start registering it first, and by get a priority date and start your publication. That doesn't matter, right? But having and holding a priority date for your particular work, and completing it and going for publication is really very valid in order to protect your invention, right? So this is really very important, right? But if this particular time is beyond 1 year oblique 12 months, this is being considered as public domain work. Okay, so you may lose, you cannot gain it. Okay, so invention means it's a new product or a process involving inventive step and capable of an industrial application. It must be new in the context of a novelness, right? It must involve an inventive step. Already we have discussed what is exactly inventive step. And it must be capable means your invention must be capable of industrial application, right? And it should not fall under section 3 and 4. Okay, so what is not granted is this, right? But still there are some exclusions. Okay, what is granted is an inventive step. Any inventive step is being granted, but what is not granted is that which is falling into the section 3 and 4. Okay, now a new means what new means what anything which is published in India, means it should not be, invention must not be published in India or elsewhere in prior public knowledge or prior public use within the India. It must not be claimed before any specification in India. So if it is so, it is not new. Now we'll consider that our work is a new one, which is not falling into this particular criteria, having an inventive step, it is novel, it has some industrial application, then it should not fall into section 3 and 4 of IP law. So this is IP law. IP law. So what exactly section 3 and section 4 is, right? So that we are going to see now. Okay. So that we are going to see. Okay, now what is section 3? Section 3 and A is like a frivolous inventions, right? Or inventions or any obvious contrary to well-established natural laws, right? So, for example, uh, uh, for example, like machine giving output without any input, right? You cannot decide such kind of thing. This is on it is on contrary to the well established natural law, right? Without any input, how you can go for an output, right? You never know an output, never get an output without an input. And you are, if you are claiming a machine which is that you design a machine which is which works without any input, then it is a frivolous invention. So you cannot claim for such kind of things, right? Or a machine is giving throughput 100% performance, beyond 100% performance. No, it is not at all possible. You cannot go beyond 100%, right? Or even giving 100% itself is a frivolous invention. So you cannot protect, you cannot claim for such systems, right? So this particular section is 3A section, right? Means anything which is which is contrary to the well established natural laws cannot be protected. For example, machine giving output without input, or machine is giving 100% performance, so this is cannot be done. Okay, so by section 3A, this can means your invention cannot be protected by section 3A. Okay, what section 3B stands? Section 3B stands that if an invention is a primary or intended use or commercial exploitation for which you could be contrary to the public order or morality. Say for example, material used for biological warfare, right? You cannot use such you cannot protect such inventions, right? So that is important. Or a weapon for mass destruction, you cannot patentize it, right? Or you cannot hold an intellectual property right. Means if your invention falls into this particular section 3B, section 3A, so such 10 sections we have into section 3 that we'll just explore very shortly, so that we can get this completed. So we can have a check and balances for this, like say section 3B causes the serious prejudice to health of a human being or animal or plant life or the environment, right? But if you look at this, an apparatus for gambling machine or theft or gambling apparatus, method of gambling, right? Adulteration of food, drug and medicines, they're not actually patentized, right? Okay, but if you look at this gambling machine, right, they are for entertainment purpose, right? But they don't reserve any intellectual property on this kind of thing. Example, right? Okay, if you look at now, if you look at section C here, right? If you look at section C here, uh, 3C here, where scientific principle or formulation of an abstract theory or discovery of living thing or discovery of non-living substances occurring in nature, right? They are not being protected, right? Mere discovery, right? Say for example, discovery of microorganism, discovery of a natural gas or a mineral. You cannot hold an IP onto this, right? So they are actually they are not considered here. Now, if you look at section 3C more, then excludes the patents on natural occurring microorganisms, right? The patents, those are onto a natural occurring microorganism, you cannot go for. But even though you can think of having it genetically modified GMOs, right? Genetically modified microorganisms are, however, patentable, right? So this is really very interesting, right? If you are genetically modifying the microorganism, then you can patent, because that involves inventive step. In case of GMOs, that involves an inventive step. So this is really very important. Now you can think of a check and balances also here, right? Okay, so this is section 3. This is what we have done. Okay, section 3D, right? So we started with A, B, C, D, right? In case of section 3D, what is going to happen? Mere discovery of a new form of a known substance, right? This is particularly with respect to uh, areas of chemistry, pharma, right? Huh? Chemistry means like organic chemistry. I'm not very good at this, huh? But still. Okay. So mere discovery of new form of known substance, which is not exclusion, which does not result into the enhancement of the known efficacy of the substance. Right? But if you look at the use of aspirin for heart ailments and new use of the neem, mere new use of neem is like you cannot protect it, right? But if you look at here, section 3D, the salt, esters, ethers, polymers, metabolites, pure form, particle size, isomers, mixture of isomers, complexes, combination and other derivatives of the known substances, right, shall be considered for the same substance. Like if they are belonging to different representative forms of a same substance, you cannot go in that particular case, right? So, but known substance with enhanced efficiency or efficacy is patentable, right? You have a known substance, but with enhanced efficacy is patentable. This is really very important. Okay, what is not? Section D, 3D, you cannot go with this, right? Means mere like combination of some of the substance, right? But if the known substance with the enhanced efficacy is a patentable, right? You can think of in that way. If you look at E, admixtures, right? Admixture means wherever you're combining two different mixtures all together and their aggregations, right? So substance obtained by mere admixtures and resulting aggregation of the properties of the components thereof, or a process producing such kind of substances are not patentable. Say for example, combiform, right? Solution of sugar and the color additives into a water to form a soft drinks and likewise, right? So again, detergent, lubricants, right? So they are going for trademarks in that case. So the check and balance you need to think of here means substance obtained by admixture resulting only in the aggregation of the properties of the components thereof, or a process producing the substances are not patentable, right? So means if your work of admixture, if you find it good, right, but then it is not patentable by section 3. So this is very important. But synergetic formulations are patentable, right? Any combination which is giving a synergy in formulation is patentable. You can think of its patentability, right? So you can think of its patentability is patentable. Synergetic formulations is patentable. Okay, now if you look at 3F, mere arrangement or rearrangement or a duplication of a known device, such as, let's say for example, such as umbrella with a fan. Fan is known, umbrella is known, right? You are placing fan into a umbrella, and stating that I have an umbrella fan, right? So you cannot go for that, right? You cannot protect. So mere arrangement or rearrangement or duplication of the known devices, each function which each functioning independently of one another, is in a known way, you cannot go for it, right? Or you can have a clock with the radio inside, right? So at the same time you can think of floor wheel provided by sewing machine. It can be like in the same way. So anything which is going into this particular form falls into section 3F. You cannot get an ownership granted, right? Now, for example, the equipments that are method of agriculture or horticulture, right? Means how to cultivate algae or in the form of a new known plant, preparation of improved soil, right? You cannot go for that. Okay, method of agriculture you cannot go for, but equipments that are appreciating the method of agriculture, right, or supporting the agriculture, the equipments are patentable, right? So this is important. So however, the agriculture equipments are patentable, Right now, if you look at section 3I, where any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or a similar treatment to animals to render them free from the diseases to increase, they are not patentable, right? Say for example, method of removing cancer tumor, if that particular method is being patented, right? So that is not actually accepted, because that is life saving, right? So life saving, so you cannot go for means you cannot live on the mercy of the people, right? So the um, act says that such kind of thing cannot be given a negative right, holding that particular IPR property. So like, but the treatment performed on the tissue, fluids permanently removed from the body, surgical therapeutics, or diagnostics apparatus instruments are patentable. So you can patentize the apparatus, right? You can patentize the apparatus, but you cannot patentize the method of removing some kind of substance, right? So this is whatever the life savings things are there, means processes are there, they cannot be patentized, but the value added services for life saving can be patentized, right? So that you need to understand. Okay, so this is important. Now if you look at section 3J, which is nothing but here, the plants or animals as whole, animal in whole, or parts of the plants, animals, seeds varieties, species, essentially biological processes, or for the propagation and production of the animal plants are not included here, so you cannot go for it. Okay, so next is, if you go with the this is particular for computer science and mathematics statistics people, that mere like you have a mathematical method, business method, or algorithms for computer program per se, they're not patentable, but any new machines which works onto a combination of hardware software is patentable, right? But uh, a computer program is itself as a record or on a carrier, so it only computer program cannot be there, right? But this is with respect to Indian context, right? In Indian context, you must have a patent process and the product, right? Or the product, right, with particular process. So this is really very important. Okay, so you can patentize the calculating machine, or a combination of hardware software is patentable in India. So this is really very important. Now if you look at literary, dramatic, or musical artistic work, or any other artistic creation, including cinematography work, televisions, right, this falls into a copyright, so you cannot go with the IPR in this particular segment. You cannot again go for skill for learning new language, solving crossword puzzles, learning new language, or teaching or learning a language, right? So you cannot go ahead with this. But novel apparatus for playing game or carrying out the scheme is patentable, right? Scheme is patentable. So, for example, any learning apparatus through which you can learn, you can patentize that. Okay, so this is important. Now there are like these two sections are there, N and O. So if you cannot patentize the method of representation of information, at the same time you cannot go for topography of an integrated circuits, like the placement of arrangement of integrated circuits in terms of electronics industry. You cannot go for it. You cannot go for inventions which are traditional, having a traditional knowledge, traditional knowledge, or an aggregation or duplication of the known properties of traditionally known components. Like we all know about that, about the use of haldi, right? So wound healing properties of haldi. So you cannot go for that, right? But like if you look at this extraction of uh, sin and from neem can be patented, right? So the extracts from neem can be protected in a certain formats, right? So it can be done. Okay. So what is non-patentable? Non-patentable, again, 4 is like anything which is coming for Atomic Energy Act, under Atomic Energy Act 1962, are not patentable. For example, invention relating to the compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium are more as notified by central government from time to time are not patentable. So section 3 and section 4, right? So this section 3 and section 4, you need to see whether your work is falling into section 3 up to P, means section 3A to section 3P, right? Section A to section 3P you need to see, and section 4 is exclusively dealing to atomic energies. Okay, so any work which is not falling into these two sections, that can be easily patentized. Okay, but there are certain exclusion also here in section 3, which we have discussed. Okay, now this is what is all about, what you can granted, what you cannot granted. Okay, so so you now, by this particular knowledge, you can easily understand, like, okay, in which section my work falls, right? Okay, but how do I search, right? How do I search? So this is really very important. You have a different mechanisms, right? Patent search mechanism. So now I am going to concentrate on to how you can search onto these different websites, right? So this is World Intellectual Property Organization. This is called as WIPO. This is World Patent Database. This is World Database of Patent. World Database of Patents. This is United States Patent and Trademark Office. This is Indian Patent Database. Right, Indian Patent Database. This is European Patent Database. This is Canadian Intellectual Property Office. This is Japanese, right? And this is Korean, right? Korean Kipo, right? So this is Korean office. We'll try to see one by one, like how you can search. This is really very simple. So I'm just stopping my screen share here and returning back to you within a moment, right? So now let me see that, do I have anything into a chat window for questions as such? No, there are no questions right now. Okay, so I hope that you're getting it well. Okay, now let me just share a screen with you all. That is a browser actually. I hope you are able to see the browser now. So this is the patent scope. This is patent scope, means this is the world database actually, world database of patents. So here you can go for searching all those patents. So the website is patentscope.wipo.int. You can go for this particular database. So simple, if you just go with this particular patent scope, you'll find it that this is world patent database, right? So just look at here. So this is World Patent Scope. This is searching database. So you can go with, like, there are different, say, simple, advanced search. You can go with the field combination. Say, for example, if you wanted to go with the field combination, you can go with this. Okay, so how you can search, like, if you can search with there are operators, right? You can go with the operators. If you know the application number, if you know the uh, if you know the publication date, if you know the English title, if you know the abstract. Okay, so if you know, right, if you wanted to go with the terms likewise. Okay, so otherwise, right, you can go with the simple search terms, right? Here, if I wanted to search, say, for example, mm, as far as your work is concerned, Can anybody help me out in just naming some of the components, like so that I can put it as per your requirement here? So if you can unmute and give me a keyword which can be searched, uh, we can go with, or because otherwise I can go with computer terms as well. So yeah, you can just drop me into chat window some terms. Okay, yeah. So cancer treatment or nano carriers. Okay, good. So we could go with nano carriers. Okay, so just search for a nano carrier. You can search for a nano carrier. Say, for example, now I'm going for searching for a nano carriers. So it will take some time and it will let you know about the result. So this is how actually it is being searched. Nano carrier is just one term, huh? So it's not a complete uh, okay. So yeah, so you got some results. Okay, so I hope my screen is visible. I'll just increase the font. Okay, now let us see. Now I hope this is visible. So yeah, just a minute, just wait for, right. I'm looking at your chat as well. Okay, so Sampada, like if you look at this nano carriers, no, you find that these nano carriers, you find around 909 results, right? So which is comprising, say, 1091 pages, 910 9 results comprising of 10 pages. Okay, now it is like you can see the first priority claim is into 2010. So by if you look at these 20 years, so it will last up to 2030. So it is in US. US stands for USA, right? United States, right? What is the here? What is the this is INTL class? INT class stands for the classification of this particular work. Then this is the application number. Who is applicant? So it is an entity applicant. So this is MIT, right? Then the inventor name is not available here. So if you look at here, the second result, look at the second result, right? You have got an applicant also, right? An inventor also. So the applicant and inventor is the same. So it is a person, right? Natural person who has applied for this. So this is in 19 say this is 2012, right? Then you have got 2020, 2010, then 2010, 2019. So recent would be 19. Okay, then 2010 and likewise. So you can search for such kind of materials onto a WIPO database, right? So you can search for this. So this is about the nano carriers. Right. So one more, I'll take one more. Okay. T. Sivramakrishnan has said that, okay, let us search for graphene. Okay, graphene is just one term. Graphene is one term. So graphene gets associated with number of terms, different terms. So how you can reduce? You can reduce your work by adding some of the operators and decide the relative search. Now, if you look at see the volume, you got 1,50,933 work on that are resulted onto uh, just onto a graphene. Now you need to add, say, graphene plus nano carriers. Okay. So I'm not very good at your subject, but I'm just putting something. So just giving you tell that this is how you can search some of the content, right? So this will be helping you to search onto a WIPO. So it will come, right? Okay. In the meantime, so the like C plus or not in these operators you can use. So just see graphene plus nano carriers. You have just got 81 results, right? So and this is giving, like, it is searching the content onto this particular graphene and nano carrier like of things, right? So you can search it out on things. So you have got right. So look at this. You have got a 2021, say October 21 uh, work, right? So you have got this October 21 work, right? April 21 work, right? So you have got this, right? Nano-enabled immunotherapy in cancer, right? So this is what database we can say, right? So this has got a nano carrier inside. So you have got this particular mechanism. So I just have opened one IPR with you all. So that is from world database. So this is nano enable immunity carrier cancer. Now what you can decide, say what you need to understand the attributes here as well, right? So what are those attributes here? So those attributes like PCT. Now, what is PCT? You can respond me into a chat window. If you understood, let me understand, like, whether you have received it well or not. What is PCT? PCT stands for, okay, fine. There's no issue. Okay, so you got a PCT data here, bibliographic data. So this is number. So you have got a publication date. You have got a PCT application, that is Patent Cooperation Treaty. So which means that this can be applicable into various number of countries, right? So this is what actually the data is, right? This is what actually data is like. So there are inventors, there are agents, and this is priority date data, right? Say it started with, it is initially registered, this particular application is registered into a US in 18 November 2019, and post that it has been submitted for uh, WIPO, right? So that is world patented database. So it is being applicable for other countries. Now, then you can go for description. So this is what exactly the description is, right? So you have got a description, right? So this is nano carriers kind of mechanism, right? And so this is, then the claims. You need to understand this important thing. Claims. Claim, any innovator who wants to register their particular work has to define claim in well-defined order, right? So unfortunately, please beg me, please, I cannot understand what is this reaction and all these means. This conjugate formulation is, right? Okay. So I cannot understand this, but you can put it, right? You can understand this, being a material scientist and chemistry person, you can understand. Okay, so it's like writing the claims, and the claim will support your work actually. So see here, graphene is included and nano carriers are included. Graphene and nano carriers are giving you more formula. See how many claims the inventor has written. 100 and just 25. So out of 125 claims, he is that innovator is restricting others. Innovator is restricting others in entering into the area of that particular invention, right? So means what you cannot means, you have to meticulously write the claims, and whenever you are writing the claims, you need to write in a very meticulously, such that you are not giving any scope for others to involve into your area. Then and then only your invention is being protected, right? Okay, so say for example, if you go with the temperature, like say here, it is like, or at least just look at this the pharmaceutical formulation into claim on 119, right? Means this right? Wherein the state suspension, emulsion, dispersion is stable at least for 1 month, or at least for 2 months, or at least for 3 months, at least for 4 months, at least for 5 months, or at least for 6 months when stored at 4 degrees Celsius, right? But any person who is taking beyond that, or right within, he has taken 6 months, 1, 2, 3, 4, 6, right? So means like, I think you have understood my concept, my intent of providing you the details. So it is like, you need to understand the you need to restrict the person. So you need to write a claim. So claim only justify for what your invention you wanted to hold with you. So that claim is very important, and it is being granted based on to the claims only. Okay. A complete application can have, one patent application can be subdivided also, right? Subdivided into the patents, right? So one patent can be subdivided also, right? So that can also be there. So if you look at the drawings, you can get the drawings also, right? So these are the drawings, right? Then if you look at the family of the patents, so it will give you that details also. So see, it's first, the title is same, immunotherapy in cancer, nano-enabled immunotherapy in cancer. So it's a 2021, right? So it is big, reagents of the University of California, reagents of the University of California, applicants. So it is an entity application. So it's like that. So you can get the notices also if there are any notices. If you want, you can get the documents as well. So you can get the documents as well. Okay, so once it is being published now, it can be accessible. Okay, so it is right, but though it is being published, the entire rights reserved for this particular application only. So applicant only. So you just see, this particular, this is 2017 graphene and nano carrier, right? So it is like this. This is how you can search onto world patent database. So means, by searching itself, you can come to the what you can say, you can decide, like if you come across with uh, any possibility of registering your particular work, right? Because by looking at this particular thing, what is available to you, right? Now let me give you in pass also, means what happens with Indian context, how you can search into the Indian context, whereas my presentation involves searching into all possible segment, including. Okay, so this is about Indian patent search. So you have got a patent register, all registered, all patents. Those are registered with Indian Patent Advance Patent or Intellectual Property Rights India, IPR India. So they are being published into a patent registers. Okay, so they are being published into a patent register. So this is how you can go for a patent registers, right? This is how you can check the status of the application. So whatever your patent application is there, you need to write that application, and you can search this captcha code you write, and you can get the status of your patent application. This is a patent register, where it will based on the dates, what I said, that within first date of registration to within 18 months, you can go for natural publication. Means without any request, your patent gets published within the 18 months. Within the 18 months, if you want an early publication, you need to pay the fees and go for early publication of the your idea. So early publication means what? It will come into the domain, searchable content. It will be a searchable content onto this particular database, right? So no doubt, if it comes into a searchable database, right, it may be a case that people may have means you may receive a conflict of interest, right? Or you may receive a conflict, or your work may receive a conflict, that okay, this is conflicting with others. So if some work is conflicting with my work, so I can submit my um, my observations onto the published patent, right? If suppose you don't have received that, right, so it means it is a good chance for getting it uh, uh, patentable, right? So now let us try to concentrate ourselves onto a search, how we can search into this. Okay, so as I said, you can go with a complete specification. A complete specification means what? It has a complete application, right? As I said, you have got a provisional application and complete application. Provisional application means what? You wanted to protect priority date, you go with the provisional application, and later it gets converted into a complete application, complete specification. Okay, so let us see that what we say, graphene plus uh, nano carriers. What about India? Okay, so what happens in India? Let's see. In complete specification, we will be searching. Either you can search in a complete specification, or you can search with the abstract also. So nano carriers and graphene, we will try to see into the abstract. So you need to provide the abstract also and this also. Okay, if you know about application number, you can search for application number and likewise. So this can be done. Okay, so you can go with this USA. Okay, so you can search for this kind of mechanism. So you don't have what such kind of mechanism here. Okay, so you don't have this here. uh, if you look at nano carriers. Okay, search for nano carriers here. So do we have? Yeah, we have got some of the nano carriers here. So how many documents? So 52 documents we have got it here. Graphene and nano carriers, this combination, right? You don't find it. So okay. So any applications you can go for, say for example, methods. See, look at method and composition of MMA constructs and vectors. So like here you can get the application status. Say this is published. You can search it for further, right? This is what actually the details, right? So see, this is international patient. Again, it is PCT application you can search for. Okay, so you can get this required. So this is file, it is published, right? Request for examination, then under examination and under dispose. Dispose means the decision have been taken, either rejected or accepted, right? Such kind of mechanism is being uh, available to you, and you can easily go ahead with this kind of thing, right? So so this is how you can particularly search about this Indian offices also, means INPAS also and WIPO also, right? Now at the same time you can search it for others database also. Like if you want to see European, or if now if you wanted to see European uh, search, then you can see that, like, just a minute. Okay, now you can go for Europe espas.net, espas.net. So you can search for your items, say for example graphene plus nano carriers. So you can search it for this. So it will take certain time, but you can look on to a search on this here. So characters are not allowed. So if you look at nano carriers directly, so see, so you got 5,483 documentations. So there are many options available. You can see that this is how it is being available, right? So this is how you can search it on to uh, various segments. Now let me go to one more So by practice, you can go on searching and see the relevancy of your work. See, by merely by not putting keywords will give you like, okay, whether your really patented work is patentable or not. By not putting just keywords, you need to go through the documents as well, and you need to see whether you are really want you have really have an option to get it registered or what. Okay, so with this I'll stop this particular sharing. Let me come back to the windows, yeah, and let me see if there are some questions for, right? There are like, say there are just 12 minutes left, so I'll just try to spend 12 minutes for question and answer sessions. So there are one more slide is remaining. Let me give you that as well. Share. Yeah, so these are the areas where these are the fields which where you can search, right? So this is Korean, Kipo, Japan, right? Canadian, right? I have given you this. I've shown you this. I have shown you this. So this you can search it out. Okay, there is a world IP statistics also available. So you can follow the link. I'll just click onto the link and will give you that details. Okay, so it will get open. I'll just stop this share, right? Okay. Okay, and then there is a Creative Commons licenses. I am not going for Creative Commons licenses here today, but it can be there. So it is used to uh, restrict people from indulging to your information which you wanted to share across the open platform. So you can bring it into Creative Commons. So, and this is last slide. Thank you very much for your patience listening. I'm just closing this particular presentation and coming back to here for your question answers, right? Yeah. Just a minute. It is moving very fast. Sorry, Veena. Sir, is it enough if I search in WIPO? I mean, does it covers all patents? Yeah, it is covering all patents, but naturally, it would be good if you search for most of the databases, right? Most of the databases, right? WIPO will really help you all, right? In all the aspects, right? But I would suggest you to like, because getting the things confirmed from multiple sources is always better in order to protect your innovation, right? So it is like that. So Veena, my suggestion to you is that yes, searching only WIPO will suffice, but would be appreciated if you search for others leading databases. And what are the leading databases that I have already shared with you all into a presentation, right? You just go with the playback of the video and get it done. Okay, is there any Siv Ramakrishnan? Is there any common search engines or website for searching all patents around the globe? No, there is no such mechanism, right? There's no one search engine for that, right? As a matter of fact, you can go for Google Patents, one mechanism. Second mechanism, you go for WIPO. Third mechanism, you go for the patent databases, which I have given to you. Right? Anything like, see, why I want you people to search for multiple websites? It is for some reason, right? That if you go with, see, it is a case that if you come up with uh, really interesting results, so it is always better if you cross validate it with the multiple databases, right? So which shows you the applicability, right? So but at this particular instant we don't find any common search engine for all patents, right? WIPO is one of the good platform where you can search. Okay, I hope Sivaramakrishnan, you have got the answer. Then next is how Deepak is saying, how could we decide publication of articles in journal? Publication of articles in journal or apply patent if there is a novel work. How would you decide a publication of articles in journal? See, Deepak, you need to decide two things, right? First, first is whether the area on which you are working is that or whatever the work that you are working is inventive or not. If it is an inventive work, it is not an extension of the work, it is an inventive work, innovative work, then you can straight away, my suggestion to you is straight away you can go for registering that particular idea and go for this. Otherwise, you if you have already come across with the publication of the work and then you wanted to apply for patent, then it should be done within 12 months, right? So that is very important, and but that is like again very difficult to justify, because you have not presented before the person who is skilled in the art, right? So it is like that. Or whether though you have presented, it is with a very limited audience, right? So that also you need to go ahead. Okay. Then so Deepak, is it compulsory to hire a patent agent, or we can do it by? Yes, Deepak, you can do it by your own. As I already said, you can do it by your own. That is really very easy. Uh, you can go with that. That's not a problem. How the thing is that how you can come to know what is actual, how what documentation is required. So there are good number of content that is already available. Due to the time constraint itself, I will not be able to share like how you can draft a proposal, but you can easily go ahead with submitting your own patent by yourself. You can go with writing a provisional or writing a complete specification will also do for you. You need an expertise of writing it in a very creative way, thoughtful way. You need to use a techno-legal language for writing your draft of application. It is not the way you are writing a scientific contribution. It is a draft where you need to see about the legal formalities as well. Legal formalities in the case of writing claims and like, so that you can restrict other people's in indulging your innovation or invention. So that also, and by practice you can go ahead with this. So if you start apart from your research work, if you start spending some time in understanding the draft, how it is being written, you can easily write your own draft as well, right? So the documentation is available. The website, Indian patent website, is really very helpful in all respects, so you can go and search your content there, right? So that is also very important. Okay. Mm, how much is cost to file a patent in India? The costing of filing a patent in India is usually 2,000 rupees, right? If you do it by yourself, but if you are taking with the help of the attorneys and all that, so the cost is depending on searching of the content, compilation, giving you the references that are cross matching with your references that you yourself has to do, right? The attorney will help you in drafting the proposal, but you need to defend your work before the attorney as well, right? So if you're taking it, so that needs a cost. But if you start going with your own self, your own way, so there is very less cost. Only you need to have a digital signature, your own digital signature. You need to create account onto Indian patent office, and you can go for submission of that, right? What draft is required and all that, you can write it down, right? You can write it down by looking at the documentation. But please try to say that it is a monopoly right, so you need to write your claim very meticulously, right? So that no one can enter or infringe into your areas, right? If you fail in writing that particular claims properly, you may lose your innovation, right? So this is really very important. How many minimum claims should be you cannot restrict. You cannot say that we will have only 10 claims or 20 claims, right? We just have come across with 120 claims, right? Claims will help you in, but there is one primary claim and all the others are dependent claims on two primary claims. So you have one primary claim and the rest are the dependent claims, right? Say you have a system, claim 119 says that you have a system based on claim number 118, right? So it is like that you can build, right? So you can put as much as, okay. Sir, if possible, can you share any example of formulate or filing a patent, right? Right now, it is not possible, Sachin. We can surely go ahead with that, but right now it is not possible. Okay. Yeah. So that's it. If you still have some of the questions, you can we can discuss. We just have 2 minutes left. If there are no questions, then Dr. Bhaskar, thank you very much for your support and giving me an opportunity to interact with the participant of AICTE ATAL program. Thank you very much.
Thank you, Pravin, for a very informative talk.
I
You
hope
wanted the
participant
format for filing a patent.
Format for
Filing and patents.
Format for filing a patent, it is very actually what I can do is like since we have configured one classroom for these students, no, so we can share a draft actually for writing a provisional specification or complete specification. We'll share them a draft, they can write it down, but I would suggest you to go for looking at, see, you need to invest some of your time in looking at what others have filed, right, or the way they have filed, right? So just look at the some of the draft they are being written, so that will give you an idea like how it is being done. Moreover, I will share the draft, a sample draft format onto Google Classroom so that it can be available with all of the people.
Okay. Thank you, Pravin sir.
Thank you, Bhaskar sir, for this wonderful opportunity to interact with the participant. I hope participant got little insights onto intellectual property rights and search. Thank you very much, Bhaskar. Thank you.
Thank you very much.
Yes.
I'm ending this meeting now.
Yes.